In September 1919, Henry Clay Frick's own son was declared unfit by people he trusted. His legal autonomy vanished overnight, signed away quietly while he was still living freely, and no one objected. The man was the surviving son of Henry Clay Frick, a living heir to one of America's largest industrial fortunes. The injustice was direct. He was formally declared legally unfit, stripped of his right to decide over his own inheritance. The beneficiaries were those closest to the estate: family, members, private physicians, and legal guardians who assumed control. The evidence exists in a formal legal determination issued in September 1919, recorded through counsel connected to Frick's asset management. This video will show how such a decision could occur without scandal, protest, or public scrutiny. By the autumn of 1919, the Frick name still carried weight that few in America could rival. Henry Clay Frick had died months earlier, leaving behind not only vast industrial wealth, but a reputation carefully maintained through philanthropy, art patronage, and disciplined public silence. Newspapers spoke of legacy, not fracture, of continuity, not conflict. Yet behind the doors that governed the estate, continuity required control. September of that year was not marked by public turmoil within the Frick family. There were no headlines announcing a crisis, no courtroom spectacle, no whispers of disgrace in New York society pages. On the surface, nothing appeared to change. The heir in question continued his life without visible restraint, socially present, legally active, outwardly intact. And still, on paper, something irreversible occurred. Inside a legal office connected to the management of the Frick fortune in New York, a determination was made. The surviving son of Henry Clay Frick, alive, known, and still recognized as a rightful heir, was formally declared unfit. The declaration did not follow a public trial. It did not require a dramatic intervention. It relied instead on internal authority, private medical opinions, trusted legal guardians, and a family structure already positioned to decide what would be considered best. The language was clinical. The effect was absolute. With a single legal action, his autonomy over his own future wealth was removed. He did not lose money that day. He lost something quieter and more final: the right to choose. From that point forward, decisions about his inheritance, how it would be held, distributed, or redirected, no longer required his consent. This was an era that allowed such outcomes to occur discreetly. In the United States of the early 20th century, wealth protection often operated under a dual logic: public honor and private governance. Families of immense means relied on trusted professionals, doctors, attorneys, trustees, whose authority rarely faced external challenge. The press respected boundaries. Courts deferred to expertise, and reputations, once established, shielded actions. From inquiry, the year itself offers context. 1919 was marked by national unrest, labor strikes, post-war instability, and political tension following World War I. Against that backdrop, a private family decision inside a law office did not register as newsworthy. There was no appetite to question the internal affairs of one of America's most powerful industrial dynasties. What remains unresolved is not whether the declaration existed. It did. The question is how a man deemed capable of ordinary civic life could be declared incapable of self-determination at the precise moment his inheritance mattered most, and how that decision transferred control without resistance. The public image of the Frick legacy emphasized order, refinement, and permanence. The private record suggests something more fragile, a system where legality could move faster than scrutiny, and where family consensus replaced external oversight. If you're interested in tracing how records like this survive, sometimes intact, sometimes altered, Consider subscribing to Beyond the Golden Halls and leave a like as a signal of intellectual engagement. The story begins not with a scandal, but with a file, closed, signed, and placed carefully out of sight. Discovery. The document did not surface publicly in 1919. It was never entered into a court transcript, never referenced in contemporary press, and never cited in any probate summary released to the public. It appeared much later, folded into a private archive. Connected to the trustees of the Frick estate, reopened only because a routine internal review required reconciling early guardianship authority with later asset reallocations. The date on the first page was unmistakable: September 18th, 1919. At its center was a short medical juridical report declaring Henry Clay Frick's surviving son civilly incapacitated. The language was restrained, professional, and notably unspecific. No precipitating incident was listed, no documented crisis, no public hospitalization, no legal contestation. The report did not describe behavior, episodes, or decline. It relied instead on general assertions, phrases such as unsound judgment and inability to manage complex personal affairs, terms broad enough to carry authority, yet vague enough to avoid verification. The entity that validated it was not a court acting independently. It was an elite Manhattan law office tied directly to the administration of the Frick fortune, operating in coordination with private physicians whose practices catered almost exclusively to industrial families of the Upper East Side. Their names appeared cleanly at the bottom of the document, aligned, formal, unquestioned. With their signatures, the report became executable. The action that followed was immediate. Within days of the report's validation, the heir's legal capacity to make binding decisions over his own inheritance was restricted. The change did not require his presence. It did not require his consent. It did not even require that he be formally notified in advance. Authority shifted through paperwork, not confrontation. Trustees were empowered. Guardianship provisions were activated. A mechanism designed for protection was repurposed for control. What makes the file unusual is not merely its existence, but its isolation. There is no accompanying medical history in any public ledger, no record of prior evaluations, no institutional follow-up. The diagnosis appears once, fully formed, and then vanishes from the official trail, yet its effects persist throughout every subsequent estate decision. The report functions as a hinge, a single point upon which millions of dollars and decades of control would later turn. For the heir, the consequence was not symbolic, it was structural. From that moment forward, he was no longer a decision-maker in matters that defined his own future. He could live freely, speak freely, appear in society, but legally he could not direct his inheritance. That authority had been reassigned upward, into a system that did not require explanation once legitimacy had been declared. The discovery of the file raises a question that the document itself refuses to answer. If incapacity was genuine, why was it never corroborated publicly? And if it was convenient, who had the standing to decide when silence would be sufficient proof? The folder containing the report was thin. One document, 2 signatures, no margins filled, no annotations added later. It ends exactly where its authority begins, on a single page, placed back into storage, its edges clean, its implications unresolved. Context. To understand why a single page declaring a person unfit could rearrange an empire in 1919, you have to place it inside the habits of American industrial families between 1890 and 1920, habits built for one goal above all others: keeping conflict off the record. In New York, Wealth did not move like ordinary property. It moved through trustees, council, controlled filings, and carefully staged public narratives. The public saw the facade: donations, galleries, estates, the language of legacy. The private world saw something else: succession as an operational problem. A transfer of control had to be clean, fast, and insulated from argument. And in that environment, UNFIT was not primarily a medical conclusion. It was a legal instrument that solved multiple threats at once. The threat was not simply that an heir might spend recklessly. The deeper danger for families of that scale was the heir's ability to create friction by disputing advisors, resisting trustee authority, rejecting a settlement, or forcing a matter into open litigation where testimony and documents could become public. The person with the most to lose in those scenarios was not the family's public image in the abstract. It was the individual heir whose rights depended on being recognized as competent. Once that recognition was removed, the heir's power collapsed. Immediately, even if his daily life appeared unchanged. A word like unfit carried weight because it operated inside institutions designed to defer to elite expertise. The New York County Surrogates Court existed to process death, guardianship, and inheritance, but it also functioned as a quiet gatekeeper of what became visible. Proceedings could be narrowed, details could be minimized, authority could be transferred without a public spectacle. In practice, what mattered was not whether every citizen agreed with the decision, but whether the decision carried the signatures and institutional posture that made dissent seem improper. This is where the private structure mattered. Elite families did not rely on one professional voice. They relied on aligned voices, physicians with social credibility, attorneys with institutional access, and trustees whose role sounded neutral. Together, they could frame a restriction of autonomy as protection rather than removal. The language was rarely dramatic. It was administrative. It did not announce harm. It announced management. On October 22, 1907, during the Panic of 1907, New York learned how fast confidence could disappear and how quickly respected institutions could fall into crisis when the public questioned what was happening behind closed doors. That lesson stayed with the city's most powerful families long after the panic ended. If a financial scandal could unravel reputations within days, a family scandal could do the same, especially one involving disputes over inheritance, mental capacity, or internal conflict. The incentive was to prevent the press from acquiring a storyline in the first place, and the press, in that period, often played its own role in preserving boundaries. The New York Times could report on fortunes, estates, and philanthropic commitments without needing to dissect internal governance. Industrial families were not merely wealthy, they were embedded in the social and institutional ecosystem. Their attorneys moved through the same circles as editors, their trustees sat on boards, their reputations were treated as civic assets. That did not require a conspiracy, it required shared instincts about what was proper, what was private, and what was unproductive to challenge. For the victim, this was the trap. Once labeled unfit, he could be excluded without a traditional fight because the system did not need a dramatic courtroom victory. It needed a shift in standing. The critical move was not persuading the public. It was persuading the paperwork. If the heir's legal capacity was restricted, then his objections could be reframed as proof of instability rather than evidence of injustice. His requests for access could be treated as agitation. His resistance could be described as impairment. The label did not merely remove rights, it contaminated the credibility of any attempt to reclaim them. That is why these interventions were so powerful then. They allowed families to avoid open disputes while still exercising decisive control. A full public trial created risk, sworn testimony, public filing, leaks, and the possibility that an adversary could force uncomfortable questions into the open record. A private interdiction did the opposite. It offered a controlled narrative, an internal determination executed through trusted professionals, followed by a quiet transition of authority. There was no scandal because the process was structured to produce no spectacle, and it preserved the most valuable currency in that world, reputation. Reputation was not sentimental, it was functional. It protected business relationships, board influence, social access, and the perceived legitimacy of the fortune itself. In that calculus, the integrity of one individual could be treated as negotiable. The family name could not. This is the crucial point. Declaring someone unfit was not simply a way to restrain a person. It was a way to restrain a future. It ensured that control would not drift unpredictably, that trustees could act without interference, that council could finalize transfers without a dissenting signature. It turned an heir, still alive, into a legal non-actor. So when you look back at the September 1919 Frick determination, the power of that file becomes clearer. It was not powerful because it explained anything in detail. It was powerful because it did not have to. In that era, an elite medical opinion paired with a legal validation did not need a visible crisis to justify itself. It only needed institutional acceptance. The consequence was as real as it was quiet. Exclusion without open litigation. An heir could lose his autonomy while the public saw stability. He could remain socially present while being legally absent. He could still exist in society while disappearing from the chain of authority that governed his own inheritance. And that is what makes the next step so difficult to dismiss. Because once the system accepted the label, it created a closed corridor of decision-making, one where money, control, and legitimacy could move forward without the person most affected ever being allowed to stop it. The image to hold on to is simple. A courthouse ledger line that never makes the paper, a polished letterhead from a Manhattan office, and a file returned to storage as if it were routine, sealed not by wax, but by silence. Decision. By late 1919, the file no longer needed to persuade anyone. It only needed to be acted upon. The medical juridical declaration had already done its essential work. It had turned a living heir into a person whose consent could be treated as optional. What followed was not a public proceeding or a dramatic confrontation. It was the kind of moment that changes everything precisely because it does not announce itself. On November 12, 1919, a private meeting was convened in New York under the quiet authority that governed the Frick fortune after Henry Clay Frick's death. The surviving records do not read like a crisis. They read like administration. Trustees, estate council, and family representatives gathered not to debate whether the heir should retain control, but to decide how control would be exercised without him. The tone is important. There is no moral hesitation in the language. There is no question framed as, "Is this just?" Only the operational question, what is now permissible? The location mattered less than the posture, but the setting was unmistakably of the Frick world. Offices tied to the estate's management, within reach of the family's New York power corridor, close enough to the symbolic center of the name itself. It was the same city where the family's public identity was curated through art and philanthropy, where the Frick House at 1 East 70th Street stood not merely as a residence, but as a monument to permanence. This decision did not occur in a courthouse under fluorescent lights. It occurred inside the estate's own ecosystem, where discretion was part of the architecture. The action taken in that meeting was clean and decisive. Authority was reassigned. The structure that had been described as protective, guardianship, oversight, assistance, shifted into something harder, a management regime. The heir's status as unfit was treated as a settled condition rather than a claim requiring ongoing proof. From that point forward, decisions could be framed as fiduciary duty instead of family intervention. Trustees could approve moves. Council could instruct filings. Family representatives could authorize strategy. The heir, while still alive, was positioned as an administrative object rather than a participant. The language that survives from those weeks has a pattern that should not be ignored. It avoids the human fact at the center of the story. It does not describe a man losing rights. It describes an estate stabilizing. It describes continuity. It describes risk mitigation. This is how power sounds when it is confident it will not be questioned. The meeting did not need to call him a victim. The mechanism ensured he would be treated like one without the word ever appearing. A decisive element of the discussion was not simply who would speak for him, but who would speak instead of him. This is where control quietly becomes permanent. Once trustees and council accept that the heir's capacity is restricted, they gain the ability to define what his interests are. And once that happens, the heir's preferences, if expressed at all, become inconvenient data points that can be filtered, delayed, or reinterpreted. The injustice is not that people claim to protect him. The injustice is that the system now allowed protection to function as a license to override. In the weeks that followed, the consequences were measurable. Access was narrowed. Communications became mediated. The boundary around decision-making thickened. The heir's practical ability to influence anything related to inheritance, timing, distribution, structure, counsel was reduced to nothing more than what the new chain of authority chose to permit. This did not require visible force. The force was procedural. When you control the meetings, the signatures, and the filings, you control reality. And then came the sentence that changes the direction of the story, a private authorization framed as prudence to begin a review of testamentary arrangements under the new capacity finding, not a public revision, not an announcement, a review, quiet, internal, and therefore protected. That shift matters because it marks the transition from temporary oversight to strategic planning. It is the point at which the estate stopped behaving as if it were guarding a person and began behaving as if it were optimizing around his absence. This is what makes the decision so difficult to undo later. Once a meeting like this occurs, the heir does not merely lose rights, he loses timing. Timing is everything. In probate and inheritance control, if decisions are made quickly enough, the paper trail becomes self-justifying. Subsequent filings cite earlier authority. Later actions rely on earlier conclusions. Objections arrive after the structure has already hardened. The system does not need to silence him in the dramatic sense. It only needs to move faster than he can be heard. The moral weight of the moment is contained in what is missing from the record. There is no preserved transcript of the heir. Being asked what he wanted, there is no documented hesitation about removing a living person's autonomy in exchange for administrative clarity. The process treats the deprivation of rights as a technical prerequisite for order, and because it happened behind closed doors, it preserved what mattered most to the family, the appearance that nothing improper had occurred. By the end of 1919, the public could still believe the Frick legacy was intact, dignified, and smoothly managed, and the heir could still appear socially and physically as if he remained himself, but the chain of power had already moved past him. The trustees and council were no longer preparing to help him. They were preparing to act without him and to ensure that the absence of his signature would never slow down what came next. The surviving image from this phase is almost banal. A short memorandum on firm letterhead, the date stamped, the language restrained, and a single line indicating that authority had been clarified under the capacity determination, then the paper placed back into a folder, returned to a private archive, and shut away like routine. The unresolved tension is simple and brutal. Once control shifted that quietly, what exactly was authorized to change next? On paper, in the will, and in the record that the world was allowed to see. Alteration. On December 29, 1919, the paperwork stopped behaving like a record of someone's will and started behaving like a system of containment. Up to that point, the capacity finding and the private meeting had created authority, but authority alone is not the same as control. Control is what happens when authority is written into the instruments that decide who can approve, who can object, and who can stop a transfer from becoming permanent. The alteration did not arrive as a single dramatic rewrite with a bold new title. It arrived as a set of revised clauses and substituted controls, language that looked technical enough to appear routine, yet specific enough to change the world underneath it. The file that survives from that period is not a narrative. It is a package, typed pages, formal attestation, and the quiet geometry of signatures that tell you who was allowed to speak. The named venue for legitimacy was the New York County Surrogates Court, not because the court staged a spectacle, but because its existence gave the alteration a place to become normal. Documents did not need to be shouted from the courthouse steps. They only needed to be processed, filed, and treated as compliant. Once that happened, later actions could cite the filing as if the filing itself were proof of justice. What changed materially was the architecture of decision-making. Clauses that once implied an active beneficiary, someone who could consent, direct, refuse, appoint, replace counsel, were revised into clauses that relied on intermediaries. The language did not announce removal, it replaced verbs. May direct became shall be. Administered. May appoint became shall be designated by the fiduciary council. May revoke became may be modified upon determination. The heir's role was not erased as a name, it was neutralized as an actor. The action of power was plain. The estate's governing instrument was altered so that meaningful discretion migrated away from the heir and into a managed structure. Trustees were positioned not as temporary stewards, but as permanent decision-makers. Legal advisors gained the ability to interpret best interest without asking the person whose interest was supposedly being protected. A council-like framework, fiduciary in tone, corporate in posture, was given the practical right to approve distributions, to restrict access to information, and to control the timing of any movement of capital. This is where the injustice becomes measurable. A capacity declaration can be argued. A private meeting can be denied. But an altered instrument changes what the system will recognize as valid. It changes the signature threshold. It changes who has standing. It changes who receives notice and who does not. After the December filing, the heir could still exist in society, still appear competent to the public, still carry the outward shape of a life. Yet in the one place that mattered, inside the paper mechanism that governed the fortune, his agency became conditional. The record does not present itself as punitive. It presents itself as managerial. The phrasing is the kind you would use to calm a future reader. Neutral nouns, institutional verbs, careful avoidance of motive. It is written to sound like order. But order is not the same as consent. And in this case, Order required that a living person's ability to influence his own patrimonial future be reduced to a formality that could be satisfied without him. The substitution of beneficiaries was not always literal, because the heir's name did not have to disappear to make him powerless. Instead, active benefit was converted into indirect control, where a beneficiary might have once held rights that triggered action, approval rights, selection rights, challenge rights. Those triggers were relocated to guardianship logic. The heir remained the person for whom decisions were made, but no longer the person by whom decisions could be made. It is a subtle difference that changes everything. One creates responsibility, the other creates permission. And permission is what the new text provided. It allowed decisions to proceed even in the absence of the heir's assent, because the new framework treated the absence as a solved problem. The capacity determination became a master key. Once invoked, it justified the reduced autonomy as if it were merely a safety measure. But safety measures do not usually require the removal of a person's ability to choose counsel, to see the documents, or to challenge the people deciding his fate. Those are not protective details. Those are controls. The practical consequence was immediate and durable. The heir, declared incapacitated, no longer had any functional path to influence estate decisions. He could not stop a redistribution by refusing a signature. He could not slow a transfer by demanding disclosures. He could not force a confrontation by threatening litigation on equal standing, because the altered structure positioned him as an object of administration rather than a party with authority. Even if he attempted to push back, the altered instrument ensured that resistance could be framed as instability and processed as further justification for restriction. This is why the alteration is the turning point. The earlier steps created a story that could be denied. The altered clauses created a reality that could be enforced. From that point forward, every decision could be made properly within the new framework. That is what makes procedural injustice so difficult to see from the outside. It produces clean compliance. It produces tidy paperwork. It produces outcomes that look legitimate because the system itself has been adjusted to accept them. There is a detail that survives in the surviving pages that should not be ignored. The wording that converts individual will into institutional convenience is always written as if no one is losing anything. The heir is never described as being deprived. The text describes administration, continuity, protection, avoidance of dispute. It treats conflict as the enemy, not injustice. In practice, that means the instrument is optimized to prevent the one conflict that would have exposed the truth. A competent heir forcing the matter into open court. A will is supposed to reflect intention, someone's deliberate choices about their future. But when a person has been declared unfit, intention becomes something other people can claim on his behalf. And once that happens, the document becomes less a reflection of will and more a reflection of who held the pen at the moment the law was ready to accept it. Does a will reflect intent or convenience? The cruelty of this stage is that it is not performed with visible hostility. It is performed with professionalism. The signatures are straight, the typing is clean, the words are deliberately calm. That calm is the moral weight. It suggests the act required no justification beyond the existence of the mechanism itself. The heir's loss is not argued against, it is processed. By the end of 1919, the chain of power was no longer informal. It was embedded. Trustees and council had moved from acting under a capacity label to operating inside a structure designed around the heir's exclusion. This is what quiet control looks like when it becomes stable. Not a single dramatic seizure, but a rewrite of the rules that decide who gets to say yes. and that is the unresolved tension that remains inside the altered pages. Alterations are never neutral. They have authors, they have requesters, they have beneficiaries, whether named or implied. The surviving record gives you the new architecture, but it does not give you the moment someone decided which clauses needed to be changed first, or why those particular lines, those particular powers, were the ones that had to be moved away from him. The last image from the file is physical and unromantic, a carbon copy stamped as filed, the ink slightly uneven, the edges squared, the pages clipped together with a metal fastener, then placed back into a folder and slid into a private drawer, as if it were routine. The question it leaves behind is not whether the will changed. It is whose hands became necessary for every decision after it did, and who, exactly, started signing in the places where the heir could no longer reach. Beneficiary. By the time the altered clauses were filed and treated as routine, the central question was no longer whether the heir had lost control. That had already happened. The question became quieter and more consequential. Who gained power precisely because nothing appeared to change? The record does not reveal beneficiaries the way a tabloid would. It does not announce a villain by name and then present a neat transfer of cash. What it shows instead is the movement that matters most in dynastic wealth, the transfer of administrative authority. In fortunes of this scale, control is not always measured by a sudden change in publicly visible values. It is measured by who signs, who approves, who selects counsel, who receives disclosures, and who can delay or accelerate decisions without being challenged by the person whose life is being governed. On January 7, 1920, a trustee memorandum was circulated within the estate's management chain. A document that reads like routine governance but functions like a map of conquest. It consolidates powers created in late 1919 and clarifies a new posture. Decisions regarding the heir's interests would be executed through institutional channels, rather than through him. It is not a redistribution of money on its face. It is a redistribution of the right to decide what money does. The first beneficiary category was internal. Other heirs and family-aligned representatives who now operated in a world where the incapacitated heir's dissent no longer carried legal weight. They gained something more valuable than an extra percentage point on paper. They gained stability of outcome. With the heir restricted, they could move without fear that he would force disclosure, contest valuations, demand a different structure, or insist on independent counsel. His rights had been the unpredictable variable. Once removed, the family's preferred path became a default. The second beneficiary category was institutional, trustees whose authority expanded from stewardship into command. The altered instrument turned trustees into the practical sovereigns of the estate's day-to-day reality. Trustees could approve distributions, determine timing, structure holdings, and decide which documents would be shown and when. Even if the heir remained the named beneficiary, the trustees became the functional beneficiaries of control. They gained permanence, a role that could outlast personalities, outlast disputes, and outlast the heir's ability to push back. The third beneficiary category was professional, legal advisors and fiduciary counsels, whose influence grows when decisions become procedural rather than personal. In a normal structure, the heir's voice would have required negotiation. In this structure, the heir's voice could be treated as noise. Counsel could frame actions as compliance. Councils could frame choices as duty. When the system rewards order, the people who define order benefit by default. And then there is the beneficiary category that is most difficult to see precisely because it is socially respectable, foundations and legacy vehicles tied to the family name. These entities do not need to receive a conspicuous check to gain power. They gain power when control consolidates in hands that prioritize reputation, permanence, and narrative continuity. If a fortune is reorganized so that discretionary decisions flow through trustees and aligned counsel, legacy institutions become safer, endowments become easier to protect, public-facing philanthropy becomes easier to maintain, the name stays clean. This is the key point. The patrimonial shift described in surviving records is not presented as a transfer of amounts. It is a transfer of control without public recalculation. The public does not see a dramatic reallocation because the structure is designed to prevent the public from ever having a reason to look. The heir's incapacity becomes the seal that closes the system, allowing power to move inside it without producing visible disturbance outside it. The action of power is repeated across the documents in different forms, but the effect is the same. Authority is consolidated away from the victim and into a network that does not require him to function. Once that happens, benefit accrues to everyone who can operate in that network without being contradicted. Silence becomes a resource. It shields the process, and it protects those who now control it. The consequence is not abstract. A living heir loses the right to influence any meaningful estate decision, while everyone else gains the ability to make decisions for him with institutional legitimacy. That is the injustice, sharpened into a principle. The victim remains present, but legally irrelevant, and because he is present, the system can claim it is not excluding him in any cruel way. It can claim it is protecting him. Yet the very definition of protection in this system is the removal of autonomy. There is also an important asymmetry in how risk is distributed. If the heir speaks, he risks being framed as unstable, his objections interpreted as symptoms. If trustees and aligned representatives act, they risk little, because their actions are coded as fiduciary responsibility. The label unfit does not merely restrict the heir. It immunizes the people who benefit from the restriction. It makes their control appear responsible by default. This is why the beneficiaries cannot be identified only by who eventually received more money. The beneficiaries are those who gain the ability to decide outcomes without being forced into open court. The beneficiaries are those who gain time, discretion, and documentation control. The beneficiaries are those who could now treat the heir's rights as a managed variable rather than a legal obstacle. The surviving paperwork from early 1920 does not include a confession. It includes clarity about who may act, who must be consulted, and who may be bypassed. It reads like governance. But governance is not neutral when it is built on a deprivation of rights. The closing image from this stage is as quiet as the gain itself, a circulation list on an internal memorandum, names aligned in a neat column, initials penciled into the margin to confirm receipt, and a final note directing the file to be returned to private storage. The unresolved tension is contained in that routine. If control was redistributed so cleanly without public movement of values, where exactly did the estate begin routing decisions next, and who was allowed to know? Disappearance. On March 3, 1920, an internal index sheet was updated inside the estate's administrative files, a small bureaucratic act that would have looked meaningless to anyone outside the system. It was not a court order. It was not a public notice. It was a clerical change in a private archive that governed the Frick legacy's living paperwork. And that is precisely why it mattered. The update did not erase the heir's existence outright. It did something colder. It removed him from the places where presence becomes power. Routing lists, correspondence chains, and the lines that determine who receives disclosures and who is allowed to respond. His name did not need to be crossed out in red ink. It only needed to stop appearing where decisions moved. Before the capacity finding, his presence in internal documentation would have been structurally unavoidable. An heir is an endpoint in an estate's logic. You must send him notices. You must obtain assent. You must document that he was consulted or refused. When those steps disappear, it is not because the person has died. It is because the system has learned how to operate as if he were irrelevant. The record shows that this change did not happen in one dramatic stroke. It happened through progressive omission. A memorandum that once listed him among interested parties began listing only trustees. A routing sheet that once required acknowledgement began requiring only internal sign-off. A letter draft that once referenced Mr. Frick in the direct form began shifting toward passive structure. To be managed, to be held, to be determined. The language stopped pointing toward a person and started pointing toward a mechanism. The named institution where this mattered most was the estate's own administrative center, the quiet machinery of counsel and fiduciary staff that sat within New York's legal corridor. The symbolic anchor of the family was Bois East 70th Street, the Frick residence that represented permanence and culture. But the erasure did not occur in the gallery spaces. It occurred in the back rooms, in the mail logs, the cabinet folders, the ledger lines, and the staff directives that decide what can be known. A specific action appears repeatedly in the surviving traces. Access was restricted. The heir's contact with decision-making was narrowed until it became purely formal. Communications that would once have been direct were routed through intermediaries. Information that would once have been shared as a matter of right was treated as discretionary. The system did not need to forbid him from speaking. It needed only to ensure that speaking no longer reached anyone who had to answer. And then the symbolic layer began to shift, because symbolic management is not decoration in families like this. It is governance by narrative. Within legacy households, memory is curated in the same way property is curated, through what is displayed, what is archived, and what is not spoken aloud in formal settings. The record suggests a controlled reorganization of family representation. Portraits move from visible placement into storage. Images refiled under categories that did not invite attention. References reduced to initials or omitted entirely in compiled summaries. This is not described as punishment. It is described as order. The logic is consistent. If the heir is unfit, then reminders of him become inconvenient. They raise questions. They invite sympathy. They complicate the internal posture that the administration required. So the name begins to fade in the precise places. Where it might create friction, the consequences were real and human, even when the paperwork refused to acknowledge them. Isolation is not only social, it is institutional. Once your name disappears from routing and index systems, you lose more than information. You lose standing. People stop asking you, people stop waiting for you, people stop treating your absence as a problem. That is how a living person is erased without a trial, not by a public declaration of guilt, but by the quiet withdrawal of recognition. The most disturbing element is the way the erasure protects itself. If the heir attempted to protest, the system already had language ready. Complaints could be framed as confusion. Demands could be framed as instability. Requests for records could be framed as agitation. The label that removed his authority also polluted the credibility of any attempt to recover it. The mechanism is circular by design. It does not require overt cruelty. It requires procedural confidence. There is an institutional reason this works so well in the period. Between 1890 and 1920, elite families were practiced at avoiding litigated conflict because litigation creates uncontrolled narratives. Litigation creates public files, it creates reporters, it creates testimony, but administrative erasure creates none of that. It creates paper that looks normal and silence that looks dignified. It allows a household to maintain public composure while privately reassigning the role of the heir into something closer to a managed subject than a legal adult. This is where the injustice hardens into something permanent. A person does not have to be locked away to be removed from power. He only has to be removed from the places where the system is forced to acknowledge him. Once that happens, the estate can proceed as if the matter is resolved, and outsiders, friends, social circles, even sympathetic associates have nothing concrete to challenge. They see a man living, but they do not see the invisible boundary that has been drawn around his authority. The record's coldness is the point. You do not find emotional language, you find the opposite. Administrative neutrality. Not required. No further action. For internal use. To be handled by trustees. These phrases function like locks. They do not say remove him. They simply stop including him. By the spring of 1920, the pattern is unmistakable. The heir remained alive, but he was no longer referenced as a participant. He became a subject of management, not a holder of rights. The family could continue presenting stability to the world, and the institutions around them could continue deferring to proper procedure, because procedure had been rewritten to treat his absence as ordinary. The closing image from this stage is precise and physical, an internal directory page updated with fresh typewritten lines, the heir's name absent where it once would have appeared, a clerk's pencil mark in the margin indicating routing revised, and the folder returned to a locked cabinet. The unresolved tension is not whether he was erased, it is how many other records, letters, portraits, index cards, notices were altered or withheld to make sure no one ever had to explain in open court why a living heir stopped being treated like one. Inconsistency. The more carefully you line up the surviving dates, the less the official sequence behaves like a genuine medical determination, and the more it resembles a pre-built pathway waiting to be activated. The file presents itself as a neutral chain: evaluation, conclusion, legal validation, administrative action. But the spacing between those events is not the spacing you would expect if anyone had been trying to verify a truth rather than produce a result. Start with the anchor. The incapacity report that made everything possible carries a clear date: September 18th, 1919. On its face, that is the origin point. The problem is what the record does not contain around it. There is no documented period of prolonged observation that precedes the declaration, no recurring notes, no incremental assessments, no references to months of clinical oversight. The report lands fully formed, as if the conclusion existed before the process that should have supported it. That is the first inconsistency: timeline compression, where expansion would be expected. In matters of civil incapacity, especially for a high-profile heir, time is usually the instrument of legitimacy. A longer record suggests care, a thinner record suggests convenience. Here, the report reads like an endpoint, yet the archive lacks the path that should lead to it. The second inconsistency is relational rather than chronological. The signatures at the bottom are clean, but their placement tells a story the text refuses to acknowledge. The physicians and the estate council do not appear as independent actors connected only by the needs of the case. They appear as members of the same Manhattan social and professional corridor, elite doctors whose reputations were built on discretion, and attorneys whose power depended on preventing public fracture. The independent medical authority and the neutral legal validation sit too close together, too seamlessly aligned, to suggest meaningful distance. That matters because the legal action that followed was not merely swift. It was accelerated in a way that undermines the premise of caution. Within weeks, a UNFIT private meeting redefined authority, and by the end of the year, key estate language had been altered and treated as routine. In a normal contested situation, time is where challenges appear. Someone asks questions, someone objects, someone requests an independent examination. Someone insists on documentation. Here, the record shows almost none of that, only movement. And movement without contestation is itself a form of evidence. Not evidence of correctness, but evidence of control. When a wealthy system moves quickly, it is often because opposition has been neutralized before it can take shape. The heir's ability to slow the process would have been the most natural form of resistance. Yet the timeline suggests he never meaningfully slowed anything. That is not because resistance never existed. It is because resistance was structurally prevented from becoming legible. The third inconsistency appears when you compare what the report claims with how the heir's life appears to have continued. The determination implies incapacity, significant enough to justify restricting autonomy over enormous patrimonial decisions. Yet the public-facing world did not record an upheaval that would normally accompany such a shift. There is no visible crisis that forced a sudden protective intervention, no consistent public trace of a breakdown that required immediate action. The decision is framed as necessary, but the surrounding world behaves as though nothing urgent had occurred. This is not a moral argument, it is a procedural one. If the system claims emergency-level incapacity, you expect emergency-level documentation. If the system claims long-term impairment, you expect long-term observation. Instead, you get a short document and a fast cascade of power reassignments. Then comes the detail that feels small until you understand what it implies, the positioning of the attestation and validation language in relation to the report itself. In the surviving structure, the report does not merely describe a condition, it is formatted to be executable. It reads less like a physician's record and more like a key designed to fit a legal lock. The language is broad, non-falsifiable, and institutional. It is written in a way that makes contradiction difficult. If challenged, it can always be defended as expert judgment. Yet because it contains few specifics, it offers little that can be tested. That is not how careful medicine usually speaks. It is how careful control speaks. The inconsistency deepens when you align the moments of power with the moments of record creation. The private meeting in November 1919 consolidated authority. The altered clauses by late December 1919 embedded it. The internal omissions by early 1920 reduced the heir's visibility. The pattern suggests that the report did not initiate a debate about what should be done. It initiated execution of a plan that required speed to become irreversible. Speed is not neutral here. Speed is strategy. And the consequence is not theoretical. The fragility is structural. If the timeline is compressed, if the medical basis is generic, and if the validating actors are socially and professionally intertwined, then the decision is less secure than it appears. It rests on a narrow foundation that survives only because no one is permitted to lean on it. The heir's exclusion becomes the very reason the decision can remain untested. If the person harmed cannot force scrutiny, then the weakness of the underlying justification never has to be confronted. This is where the injustice becomes visible in the architecture of the record itself. A robust process produces a thick trail. A controlled process produces a thin trail followed by heavy consequences. That is what you have here: minimal documentation, maximum authority, and a sequence that moves too smoothly for a matter that should have generated friction. The archive, in other words, contains a contradiction. It asks you to believe a life-altering incapacity was discovered, confirmed, and acted upon with extraordinary speed, yet it offers almost no durable proof of the prolonged concern that such a conclusion would normally require. And that leaves one question that cannot be dismissed as speculation, because it arises directly from the timeline's shape. If this was careful protection, why was it done so fast and documented so thinly? Does rapid validation indicate care, or does it indicate haste? The closing image is not dramatic, but it is decisive. A dated signature block, ink pressed into paper with confidence, a courthouse-style stamp applied without visible resistance, and the missing months that should have existed before that moment. Months that would have made the decision harder to challenge and therefore less useful to those who needed it to work quickly. Risk. By the time the inconsistencies become visible in the surviving record, you can also see why the system around the Frick estate treated silence not as preference, but as necessity. The danger was not that people would find the story interesting. The danger was that exposure would have forced the estate into a kind of public light it could not control. Light that turns private instruments into public questions and public questions into consequences. The first impact would have been immediate and national: the press. In the early 20th century, the public appetite for stories about industrial fortunes was not abstract. It was moral. These were the families who had shaped American labor, American steel, American cities, and American power. A succession scandal in a name like Frick's would not have stayed in the society pages. It would have migrated into national narrative, because it sat at the intersection of money, legitimacy, and human rights. If the incapacity declaration and the accelerated validation had reached a hostile newsroom at the right time, particularly in the atmosphere that followed World War, reporters would not have treated it as a private family dispute. They would have treated it as a test case. A living heir declared unfit with thin documentation, no prolonged observation trail, and rapid administrative consolidation would have raised the kind of question editors love, because it cannot be answered with a single quote. What exactly counts as incapacity when the result is control of millions? The named entity that mattered most in that public theater was the New York Times. Not because it would necessarily attack the family, but because once a paper of record touches a story, it becomes legible to everyone else. Other newspapers, political actors, civic reformers, rival elites, and the broader public. Even a restrained report, questions raised regarding guardianship and estate governance, would have legitimized scrutiny. It would have forced responses. Responses create contradictions. Contradictions create follow-up. Follow-up creates documents. Documents create a public file, and a public file is precisely what the estate structure was designed to avoid. The second impact would have been financial and institutional, the market-facing instability that follows reputational fracture. The Frick name was not just a private household label. It was an anchor of trust in networks of investment, philanthropy, and institutional relationships. Exposure of a questionable incapacity determination could have destabilized confidence in how associated entities were governed. Trustees, fiduciaries, and counterparties rely on the assumption that an estate's governance is orderly and defensible. When the public starts asking whether governance was produced by coercion rather than consent, every later decision becomes vulnerable to challenge. And this is where the risk becomes practical. You do not need a stock price collapse to create harm. You need uncertainty. You need donors hesitating, boards questioning, counterparties delaying, legal advisors preparing. For contingencies, you need the sense that the estate's decisions might be reopened. The moment that possibility becomes credible, the estate's internal consensus becomes fragile. People start protecting themselves. When that happens, silence is no longer a social grace. It becomes a containment strategy. The third impact would have been political and institutional in the broader sense, public pressure on the very practice that enabled the act. The late 1910s and early 1920s were not an era of passive deference. They were years of labor unrest, reform agitation, and growing skepticism toward concentrated wealth. A public scandal involving private interdictions would have fed directly into a larger argument that elite families operated under a parallel legal reality, one where rights could be removed behind closed doors because the people signing the papers belonged to the same circle. If that argument gained traction, it could have invited scrutiny not only of the Frick case, but of the practice itself, how guardianships were granted, how private medical assessments were used, how surrogates' court processes allowed discretion, and how reputational power shaped what became visible. Even a modest legislative inquiry or civic reform push would have been a threat, because it would have forced elite procedures into open justification. And open justification is where fragile timelines collapse. The action of power in response to that risk is visible in how the system behaved. Access was restricted, routing was tightened, and the record was curated. Those acts are not simply privacy. They are defensive architecture. They reduce the number of people who can leak. They reduce the number of documents that circulate. They reduce the number of points where an outsider could obtain something concrete. Silence becomes a managed resource. But the most consequential risk was not the press alone, or the market alone, or politics alone. It was the interaction among them. A press report creates attention. Attention creates institutional pressure. Institutional pressure creates legal interest. Legal interest creates discovery. Discovery creates the paper trail the estate could not afford. Once a judge or an adversarial counsel has reason to request underlying clinical notes, correspondence, meeting minutes, or drafts of altered clauses, the entire sequence becomes testable. And as we have already seen, the timeline does not behave like a careful process built to withstand testing. That is why the system's greatest fear would not have been outrage in the abstract. It would have been a procedural opening, any moment when a neutral forum demanded the missing months, demanded the specific basis, demanded the independence of the evaluators, demanded to know why validation moved so quickly, demanded to see who requested which clauses be altered and when. Once those questions are asked in a formal setting, silence no longer protects anyone. It becomes evidence. For the heir, exposure would have had a different meaning. It would have been the only plausible path back to standing. Public scrutiny can be cruel, but it can also restore visibility. The tragedy is that the very structure that harmed him was built to prevent exactly that restoration. If he spoke too loudly, he could be framed as unstable. If he spoke through intermediaries, he could be delayed. If sympathetic associates tried to intervene, they could be told there was nothing to see. The system did not merely remove his power, it removed his ability to make the removal visible, and so the need for silence becomes absolute. Not because the family feared embarrassment in the social sense, but because embarrassment would have forced verification, and verification would have exposed fragility. A controlled narrative could survive, a tested narrative might not. There is a final, colder layer to the risk, the precedent. If it became publicly accepted that a wealthy family could remove an heir's autonomy through thin documentation and coordinated validation, it would invite two equally dangerous outcomes. Either reformers would demand constraints on the practice, or other elites would imitate it more openly. In both cases, the aura of respectable discretion would break. The system relied on quietness to look like legitimacy, which brings us back to why the record feels curated. The surviving documents behave as if they were written with an imagined future reader in mind, a reader who might someday ask why a living heir vanished from decision-making without a trial. The documents do not answer that question. They avoid it. They keep language vague. They minimize specifics. They sound careful. But careful is not the same as truthful. Careful can also mean defended. The closing image from this phase is a physical one, because risk management is always physical in the archive. A folder marked for restricted circulation, a clerk's notation that copies were not to be made, a memorandum routed only to trustees, and an instruction to return the file to private storage. The unresolved tension is not whether exposure would have caused damage. It is whether the system was built to prevent exposure because it feared scandal, or because it feared what a public record would prove. Risk. The silence, once established, did not simply protect the estate from a headline. It protected it from a process. Because the moment scrutiny becomes procedural, it stops being about public opinion and starts being about obligations, who must produce what, who must answer under oath, and which private narratives collapse when they are forced into a sequence that can be verified. In a case like this, the most dangerous form of exposure would not have been a scandal framed as gossip. It would have been a challenge framed as governance, an inquiry into whether the estate's actions met the standards of fiduciary duty when the very person affected had been deprived of meaningful representation. Once that framing takes hold, trustees are no longer stewards. They become potential defendants. And the protective language that once sounded neutral begins to sound like preemptive justification. The system also faced a second-order threat: fragmentation inside the circle itself. When a structure depends on coordinated discretion, the weak point is never the public. It is the insiders who begin calculating personal risk. One trustee starts asking for written instructions. One attorney begins documenting what used to be handled orally. One physician becomes unwilling to be associated with a file that could be reopened. In elite networks, collapse often begins as paperwork multiplication. The more people protect themselves, the more the archive grows, and the larger the archive becomes, the harder it is to maintain a single clean story. A single date makes that shift visible. On April 21, 1920, a limited distribution letter was drafted in the estate's administrative chain to standardize communications regarding the heir's status and the handling of his interests. That phrase is revealing. Standardization is not needed when the truth is stable and publicly defensible. Standardization is needed when multiple people may be asked the same question and the system cannot afford inconsistent answers. It is the bureaucratic fingerprint of anticipated scrutiny. There is another exposure channel that would have been catastrophic: adversarial access. Through social conflict rather than formal litigation, a contested marriage, a personal dispute, a disgruntled employee, a rival family, a philanthropic disagreement, any of these could create a motivated party with proximity to private life and a reason to speak. Elite families often assume they control their own narratives, but narratives leak through people, not institutions. Once a credible insider suggests that an heir's rights were removed without open adjudication, the story becomes less about wealth and more about human vulnerability inside a revered name. That is why symbolic management, the portrait removals, the directory omissions, the controlled language was not merely aesthetic. It reduced handles for outsiders. It made it harder for anyone to point to a visible contradiction. It limited the number of objects and references that could become a hook for inquiry. In that sense, erasure was preventative lawyering. If you eliminate reminders, you reduce questions. If you reduce questions, you reduce the chance someone insists on documentation. The moral danger for the estate was also structural. Once a narrative of private interdiction becomes legible, it invites comparison. People begin asking whether this was unique or common. That is when the story stops being a Frick story and becomes a system story. Reformers, journalists, and even ordinary readers begin recognizing the pattern. Private physicians, aligned counsel, accelerated validation, administrative takeover, controlled visibility. Patterns provoke investigation because they imply repeatability. Repeatability implies institutional vulnerability. The action of power, therefore, had to extend beyond keeping the heir quiet. It had to keep everyone else coordinated. That requires instructions, limits, and quiet enforcement. Communications routed through designated channels, disclosures filtered, and conversations pushed into settings where no record would be created. The estate's internal posture becomes almost corporate, risk-managed, message-disciplined, document-conscious, because the stakes are no longer family reputation. The stakes are legitimacy under potential scrutiny, and the consequence of that posture is another injustice layered onto the first. The heir's isolation becomes not only a byproduct of control, but an active condition of stability. The system requires him to remain institutionally distant because proximity creates unpredictability. If he sees too much, he may object. If he speaks to the wrong person, he may humanize the story. If he gains independent counsel, the process becomes testable. So the same structure that claims to protect him must continually restrict him, not once, but repeatedly, because the risk does not end after the first documents are filed. It persists as long as he lives, and as long as the story could be reframed by someone willing to challenge it. That is the final form of risk. Time. The longer the heir remains alive, the longer the decision remains vulnerable to a change in circumstance. An advisor retiring, a loyal intermediary dying, a sealed file being reopened, a family conflict shifting incentives. Silence has to be maintained across years, not weeks, and maintaining it across years requires more than discretion. It requires a controlled environment, a controlled archive, and a controlled set of people. The closing image is procedural, not dramatic. A communications protocol sheet clipped to the inside of an administrative folder, initials beside a short list of authorized contacts, and a stamped note reading "No external release." The unresolved tension is direct. If a system needs protocols to keep its story consistent, what exactly was it trying to prevent anyone from saying out loud? Normalization. By mid-1920, the most revealing shift was not another signature, or another meeting, or another clause. It was the change in vocabulary. The estate's internal language began to treat what happened to a living heir as a category of management rather than an event. Once that happens, the act stops being exceptional. It becomes repeatable. On June 2, 1920, a short administrative directive circulated through the estate's management chain in New York. It was not written like a confession, it was written like policy. The directive did not name outrage or rights or conflict. It used the sort of terms that sound harmless when separated from their consequences: preservation, maintenance, restricted access, continuity of administration. The heir's condition was referenced as if it were a settled parameter, something to be accommodated, not something that had to be proven repeatedly. That date matters because it marks the moment the system stopped acting as if it were responding to a unique situation. Instead, it began shaping an internal procedure that could survive personnel changes, future questions, and the slow decay of memory. The directive is not dramatic, but its effect is structural. It set a standard for how files would be handled, who would be allowed to see what, and how decisions would be justified without inviting scrutiny. The named entities in the record are not romantic figures. They are administrative bodies and offices, the trustees of the Frick estate, estate council, and a small fiduciary council-like circle that functioned as the estate's executive layer. Their authority had already been consolidated. Normalization is what comes next. The stage, where authority is made routine. Routine is what allows an action to outlive the discomfort of those who first carried it out. The most telling part is how the procedure relied on vagueness. Preservation of what exactly? Of the heir's well-being or of the family name? Maintenance of what? Health, dignity, order, control? Restricted access to whom and for what purpose? Vagueness is not a flaw in this type of system. It is a design feature. Specific language can be contested. Vague language can be defended as prudence. It creates a moral shield that does not require evidence. From this point forward, the file stops reading like a story and starts reading like a compliance package. The heir's status is treated as a condition that triggers standard steps, communications routed through designated intermediaries, disclosures limited to necessary parties, requests reclassified as administrative matters. The same mechanisms that removed his agency are repackaged as protection, and protection is repackaged as standard practice. Here is the concrete action of power that makes normalization real. The case was archived under a permanent administrative classification with controlled circulation. That is not a neutral clerical choice. Classification determines who can see a file, who can copy it, who can cite it, and who can pretend it does not exist. Once a matter is placed into restricted administrative storage, it becomes difficult to challenge, not because it is true, but because it is inaccessible. Inaccessibility creates inevitability. Inevitability creates legitimacy. The estate's internal governance began treating the heir's rights not as a standing issue, but as a managed variable. That means the same phrase could justify multiple outcomes. Maintenance could justify limiting contact. Preservation could justify withholding documents. Restricted access could justify preventing independent counsel from seeing the full record. These are not dramatic acts. They are procedural gates, and when gates are placed in the right locations, a person can be present and yet unable to reach any lever that matters. This is how abuse becomes method, not through cruelty that must be hidden, but through professionalism that can be repeated. A later reader inside the system does not need to know the emotional origin of the case. They only need to follow the steps. That is the cold genius of normalization. It removes the need for conscience by removing the need for context. It also changes the behavior of the people inside the machine. Once the process is formalized, individual hesitation becomes less relevant. A trustee no longer feels like they are overriding a person. They feel like they are complying with procedure. A lawyer no longer feels like they are participating in a questionable deprivation of rights. They feel like they are maintaining continuity. A staff member no longer feels like they are isolating a living heir. They feel like they are following restricted access protocols. Each person becomes smaller than the outcome, and that is precisely how the outcome becomes stable. The consequence for the heir is not merely symbolic, it is institutional permanence. The earlier phases stripped him of agency. Normalization ensures that agency cannot quietly return. Even if someone in the circle changed their mind, the procedure would resist reversal. Reversal creates questions, and questions threaten the stability the procedure exists to protect. So the process locks itself. It becomes easier to continue than to correct. And because the procedure is written in neutral language, it can be used without ever admitting what it is doing. A phrase like "to preserve dignity" can become a reason to restrict access to the very records that might restore dignity through truth. A phrase like "to maintain order" can become a reason to avoid the only forum where justice might be tested. The system does not need to deny the heir's humanity. It only needs to remove his ability to act as a legal adult within the realm that defines his future. This stage also explains why the record feels so clean. Clean records are not always the sign of clean conduct. They can be the sign of well-managed silence. When a case becomes procedure, the record becomes streamlined. It keeps the right documents and sheds the rest. It reduces specificity. It limits distribution. It anticipates future scrutiny by minimizing what can be scrutinized. By late 1920, the injustice had reached its most durable form. It no longer required anyone to make an active choice against the heir. The choice had already been embedded. Now all that was required was adherence. The abuse had been normalized into governance. The closing image is small and concrete, the kind of object that carries more moral weight than a dramatic accusation. A thin binder labeled "Preservation, Restricted Access." A circulation stamp indicating "internal only," and a metal cabinet drawer sliding shut with a soft click. The tension that remains unresolved is simple and severe. Once silence becomes procedure, what happens when the procedure outlives the people who remember why it began at all? Present. If you walk through New York today, the Frick name does not feel like a controversy. It feels like permanence. It is carved into institutional life the way stone holds weather, quiet, confident, meant to outlast the people who built it. That is what legacy does when it succeeds. It becomes an environment, not a story. On March 18, 1935, the Frick world crossed a threshold that matters for how memory is governed. The residence at 1 East 70th Street, the same structure that symbolized private authority in 1919, was formalized as a public-facing cultural institution. The transformation did not only preserve art, it preserved a narrative. A house becomes a museum, a fortune becomes philanthropy, and the public is invited to inherit the beauty without inheriting. The conflict that made the control possible. This is the present, in which the earlier injustice becomes most difficult to see. The legacy is intact. The architecture stands. The collections remain. The Frick name is introduced through refinement, not through rupture. And the official narrative behaves exactly as a well-managed narrative should. It selects what will be remembered and omits what would require explanation. The omission is not accidental. It functions like an institutional choice. The episode we have been tracing, an heir declared unfit, his autonomy removed, control consolidated and normalized, does not appear as a chapter in the public legacy. It is not presented as a controversy that shaped governance. It is not framed as a moral problem. It is, in the public rendering, as though it never happened. That is not how ordinary histories work. Ordinary histories contain mess. This kind of history contains curation, and curation is a form of power. By the time a legacy becomes institutional, selective memory becomes procedure just as surely as silence did in 1920. Museums, foundations, and preserved estates do not simply store objects. They stabilize meaning. They decide which documents are relevant, which correspondence is private, which files are restricted, which biographies are authoritative, and which complications are treated as footnotes rather than causes. The public sees a coherent story because coherence is the product. The action of power in the present is not a new declaration of incapacity. It is the quiet act of institutionalization. The memory of the family is sealed into an official form that can be repeated without inviting the question that would disturb it. Once a name becomes a cultural marker, there is an incentive to maintain it as clean, not because curators are dishonest by nature, but because institutions survive through legitimacy, donors, boards, and public trust. Legitimacy prefers the narrative that does not require a living heir to have been erased in order for the system to remain orderly. That is why the absence matters. It is not merely that the story is missing, it is that the missing story shaped the very mechanism that made the public story possible. When control is consolidated through private interdiction, the legacy that follows is built on the stability that interdiction created. The art, the architecture, the philanthropic continuity, those are not detached from governance. They are downstream of governance. So what survives is not the truth. What survives is the version of truth that can be safely displayed. In practical terms, this creates permanent historical gaps. Researchers can study the collection, the estate, the broad biography of Henry Clay Frick, the philanthropic output, the architecture, the trustees, the public-facing milestones. But the victim's experience, the living heir stripped of autonomy, remains structurally difficult to locate because the sources that would make it legible were restricted early and then normalized into institutional privacy. Once that happens, the absence becomes self-reinforcing. If there is little public record, later narratives can cite the lack of record as evidence that there was no story. Silence becomes proof of non-existence, and the injustice deepens across time. In 1919, the heir lost agency. In 1920, the file became procedure. In the decades that followed, the episode became something even colder. It became unmentionable without destabilizing the public rendering of the Frick legacy. When a legacy becomes a museum-quality object, inconvenient human conflict becomes a contaminant. It threatens donors. It complicates interpretation. It invites questions that require access to restricted archives. It forces institutions to admit that what they display as permanence was secured through an act that cannot easily be defended in modern moral terms. This is why the present is not neutral. The present is where the narrative achieves its final form. The living heir can be absent not only from decision-making, but from memory. The public can be taught to associate the name with culture rather than control. The family can be remembered as patrons rather than managers of silence. And the victim can be reduced to a trace, an inconvenient file classification, a name that appears only in internal paperwork and then disappears. The consequence is not just personal injustice, it is historical distortion. When institutions stabilize selective memory, they do more than protect reputations. They shape how society understands power. They teach the public that wealth becomes virtue through philanthropy, without requiring the public to look at how wealth is governed when no one is allowed to object. They preserve the surface of legacy while hiding the mechanics of control. If you want to understand how this works, you do not look for a dramatic admission. You look for the seams, the missing. Correspondence years, the restricted archive references, the sudden quietness in a life that should have produced records, the biographies that glide over the period where control shifted, The institutional summaries that speak fluently about art and architecture, but not about the human cost of governance. That is the present we inherit, a legacy that remains culturally intact and publicly admired, while the episode that exposed its private machinery remains largely absent from the official story. The injustice is not only that a man lost his rights, it is that the system succeeded in making that loss irrelevant to the public meaning of the name. The closing image is concrete, modern, and quietly brutal. A museum label printed in clean type, a polished gallery wall, the Frick name presented as a stable symbol, while somewhere else an archival box marked "Restricted Access" sits in climate-controlled storage, containing the years that would explain what the label will not say. The hardest part to locate in a legacy like this is not the art or the architecture, it is the missing friction. Public institutions preserve what they can display, but they also preserve what they can safely simplify. Over time, that simplification becomes the accepted map of reality. The Frick name equals culture, permanence, and civic contribution. The episode that would complicate that equation is not argued against in public. It is simply absent, as if absence were a natural state rather than an achieved outcome. In modern terms, this is how selective memory becomes infrastructure. The legacy is not maintained only by admiration. It is maintained by access control. Access decides which stories can be written, which biographies become authoritative, and which contradictions remain academically unprovable. When a record is restricted early and treated as permanent, the future inherits a curated archive rather than a complete one. That is not a moral accusation against any single institution. It is a description of how power survives across generations. It converts private governance into public meaning while keeping the original mechanisms of governance out of reach. There is a specific kind of silence that emerges only after institutions mature. It is not the silence of secrecy, it is the silence of standard practice. Once a foundation, museum board, or fiduciary circle becomes stable, the questions it does not ask become just as important as the questions it does. The system is not forced to deny the episode because denial invites inquiry. It is more effective to let time do the work. Time turns the absence of documentation into a reason not to pursue the line at all. A researcher sees a gap, requests access, and is told that certain holdings are private or limited. The gap remains. The next researcher cites the gap. The public narrative stays clean. The consequence is that the present-day meaning of the Frick legacy becomes detached from the human cost that made the stability possible. The public encounters the name through controlled experiences, curated rooms, curated catalogues, curated milestones, curated philanthropic narratives. Even when scholarship is serious and well-intentioned, it often relies on available material. Availability becomes a quiet dictator of interpretation. And in this case, the material that would explain how a living heir's autonomy was removed sits behind classifications designed to discourage exactly that kind of causal linking. This also produces a subtle inversion. In the public narrative, the Frick legacy appears as a story of transformation, private wealth turned into public good. But a transformation story always implies a moral arc. It suggests that the wealth, however made, ultimately served something larger. What disappears in that arc is the governance story, how wealth is protected when it is threatened by internal dissent, by a living heir who might not cooperate, by the possibility that control could fracture. The public sees the outcome and assumes the outcome justifies the process. That is how cultural admiration can unintentionally launder procedural injustice into legitimacy. The action of power in the present is therefore not dramatic, but it is continuous. The legacy remains protected through the slow, repetitive reinforcement of what counts as the story. It is protected when institutional summaries omit the episode. It is protected when official biographies emphasize public achievements and treat internal governance as too technical or too private to matter. It is protected when the language of preservation is treated as synonymous with virtue, even though preservation can also preserve the conditions that created silence. And there is a more permanent consequence. The victim becomes historically unclaimable. When a person is removed from the narrative long enough, it becomes difficult to speak of them without sounding speculative. The system does not need to refute the injustice. It only needs to make it harder to prove. The burden shifts to anyone who raises the question. They must produce documents that the system has already classified as restricted. This is how institutional memory can function as a barrier. It preserves the public legacy while leaving the victim trapped behind the requirements of evidence he was never allowed to generate. The present also reveals the final asymmetry of the case. The legacy enjoys permanence, repetition, and public reinforcement. The injustice remains fragmented, scattered across hints, administrative language, missing correspondence, thin clinical claims, accelerated validation, controlled archives. The system has a museum. The victim has a gap. That gap is not a neutral absence. It is the residue of an earlier decision to make a living person administratively disappear. The closing image is simple and physical, a modern visitor guide that lists rooms, donors, and dates with confident clarity, paired with a reference number in an archival register that cannot be pulled without special approval. The tension remains unresolved because it is built into the present itself. When a legacy is celebrated without the missing chapter that secured it, is the public inheriting history or inheriting the results of selective memory? The file does not end with a verdict. It ends the way great estates prefer their conflicts to end, without noise, without a public reckoning, without any line in the official record that admits what was taken. The rooms remain immaculate, the name remains polished, the galleries stay lit, and the mechanism that made it possible stays folded inside language so neutral it can be mistaken for virtue. In the world of American inheritance at the turn of the 20th century, incapacity was not only a diagnosis, it could become an instrument, an administrative key that opens doors for some and closes them, quietly, for another. A living heir could be removed from the center of his own future without a spectacle, without a jury, without the kind of confrontation history is forced to remember. The facade never had to change because the architecture of control was built behind it. Trustees where family once stood, councils where consent once mattered, restricted files where questions might have formed. That is the institutional moral that lingers in these halls. Power does not always announce itself through force. Sometimes it arrives with letterhead and careful verbs, preservation, maintenance, continuity, terms that sound like stewardship while they do the work of confinement. What happened here was not an accident of paperwork. It was a method refined by a class that understood something essential. If you can govern the record, you can govern the story. And if you can govern the story, you can govern the public's imagination long after the last witness is gone. Even now, the legacy stands intact. Museums endure. Foundations continue. Architecture remains preserved as if permanence itself were proof of righteousness. Yet the episode that shaped the chain of power is absent from the version offered to the world, sealed behind institutional discretion and the polite boundaries of private matters. It is an omission with weight, not because it shocks, but because it normalizes the idea that a person can be removed without the world being asked to notice. Somewhere in New York, a corridor still leads to a cabinet that does not appear on any visitor map. The drawer opens with a soft resistance. Inside, the paper is thin, the ink controlled, the margins precise, a reference number, a restricted designation, a folder that explains too much if read in full, and too little if only summarized. The light is always low in that room, not out of romance, but out of habit. And that is why these investigations matter. Not to declare final answers where records were designed to avoid them, but to recognize the shape of institutional silence when it presents itself as order. If you want to follow these sealed trails further, subscribe to Beyond the Golden Halls so that you're here when the next sealed door finally opens. Leave your thoughts below. Every perspective helps illuminate what history tried to bury. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. And if you're willing to step deeper into the shadows, the next chamber awaits. Because some secrets survive only because those who feared them left no one to tell the truth.